Okay, this is a copy of a presentation that I gave to Ashton College, which provides continuing legal education services to immigration consultants on December 7, 2023. The topic was Inadmissibility, Case Law, and Ministerial Intervention. I spoke for between 45 minutes to an hour at that presentation, but I'm hoping to provide on this YouTube video a more succinct version of that presentation in around 10 to 15 minutes. It's a complicated topic, but I hope that by the end of the video, you have a general understanding of inadmissibility case law and ministerial intervention going into 2023-24. So at the end of 2023, there were several issues that were emerging and themes that were emerging in Canadian immigration law regarding inadmissibility. Deanna Okanachoff and I on my podcast, Borderlines, have touched on several of these issues and commented how inadmissibility, specifically security inadmissibility and human rights inadmissibility, is playing an increasingly prominent role in Canadian immigration law. So we had first, towards the end of 2023, although it was seen throughout 2020, end of 2022, 2023, increased security delays for Chinese nationals and admissibility hearings involving the PLA. And this followed by the federal court decision in Lee v. Canada, which I will get to in a future slide. That case actually post-dated this presentation that I originally gave to Ashton College, but it's so significant that I added it here because I felt like it's a significant enough case that I would not be doing the audience a service to not mention it during this presentation. The other thing that happened this in December 2022, but it was in December 20 or it was in 2023 that the implications were was the designation of Iran under Section 35 of the IRPA as being a regime that engages in systemic human rights violations. The consequence being a whole swath of Iranians became inadmissible to Canada, and there's also increasing calls to designate the Islamic Revolutionary Guard Corps as a terrorist entity, which will further result in an increasing swath of the Iranian population being inadmissible to Canada. There's also the introduction of a new Section 35.1 of the Immigration and Refugee Protection Act, inadmissibility due to sanctions. It's brand new, hasn't really been used yet. There was towards the end of 2023 the allegation that India was involved in the assassination of a Canadian. The ramifications of that are still unknown. And finally, it's a bit cut off by my head here, I think, but there was a federal court decision where the federal court ruled that it was unreasonable for IRCC to determine that an individual who was a member of the Palestinian Authority was inadmissible to Canada. And what I just found noteworthy of that case, it kind of slid under the media, was especially in the context of the ongoing war between Hamas and Israel, where the Palestinian Authority is presented as sort of, you know, the alternative for Palestinian government, that the Canadian government or the Canadian state had determined that membership in that entity, the Palestinian Authority, resulted in inadmissibility due to membership in a terrorist organization. The federal court ultimately struck down that decision. So this is the section that kind of covers most of this, Section 34 of the Immigration and Refugee Protection Act. It provides that a permanent resident or a foreign national is inadmissible on security grounds for, and then a whole bunch of things. It's important to note here that it's permanent resident or foreign national. And the first one, A, engaging in acts of espionage that is against Canada or contrary to Canada's national interest. B, engaging in or instigating in subversion. C, engaging in terrorism. D, being a danger to the security of Canada. E, engaging in acts of violence that would or might endanger the lives or safety of persons in Canada. And F, being a member of an organization that has engaged in or will engage in or is engaging in any of the above activities. That's the broad one generally known as membership, where I think you'll find most of these cases arise. Espionage, I've reproduced or listed some of the main cases, or key cases anyways, in this area. I'm going to go through them quickly for the purpose of this YouTube presentation, but I encourage you to read these decisions if this is an area that interests you. The first is Afanaseyev v. Canada Citizenship and Immigration. That is the a federal court decision that's kind of notable because it talks about how Canadian immigration legislation doesn't define espionage and how it's sort of been up to the courts and essentially to determine what is a reasonable interpretation of espionage. It's generally been thought of where an individual, on behalf of a foreign entity or state, obtains information through some sort of inappropriate means that is contrary to Canada or Canada's interests. In Levy Canada, Citizenship and Immigration 2023 FC 1753, this definition was greatly expanded. Deanna and I did a whole podcast on this decision, which you can find both on any podcast player as well as the Borderlines YouTube channel. And we talked about Levy Canada in that decision, which has had significant repercussions. And essentially, the Chief Justice of the Federal Court ruled that what Canada considers to be espionage needs to expand in the modern age, and specifically that there doesn't have to actually be a subversive element to the way that an individual gets information about Canada that is given to foreign actors. It can be publicly available information. And B, perhaps most significantly, and the one that is having the most relevance now, is that it can encompass scenarios where someone in the future may be co-opted or coerced into providing information to a foreign state. So in this case, Mr. Lee was found inadmissible for espionage, not because he currently is a spy or even that he wants to be a spy, but that in the future the Chinese state may coerce or co-opt him into returning to China to give information to them that he had learned in Canada. It's a very broad decision. Again, for more information and discussion about it, I encourage you to check out the Borderlines episode that Deanna and I did for our podcast, and I'll link to it in the YouTube show notes below. The next case, Idagao v. Canada Citizenship and Immigration, that involved an individual who was found inadmissible for espionage. He was Ethiopian, and he was spying on his own citizens. And the Department of Justice and IRCC tried to argue that, there's a charter values element here where Canada doesn't like it, that people, Canada doesn't like regimes that spy on their own citizens, and that the person should be inadmissible. Federal court struck that down and said that it is essential that the espionage be against Canada or against Canada's national interests, and that spying on your own citizens doesn't meet that threshold. Gung v. Canada is a 2023 decision where an individual who worked for the Luoyang Foreign Languages Institute was found inadmissible, essentially because part of his role in teaching English was to teach English to members of the 3PLA, which very simply, and this is a huge simplification, is kind of the spy element of the People's Liberation Army. Federal court, Justice Mosley, struck that down, saying that just because someone taught English at a university and some of the students were 3PLA members does not mean that that person was a member of an organization that engaged in espionage. Kanagendran is a case that I cite quite a lot. It's a federal court of appeal decision, and basically it stands for the principle that great care needs to be exercised in determining if somebody is inadmissible to Canada for being a member in an organization that has committed espionage, where they are a member of a proxy organization. So, for example, going back to Gung, they essentially were arguing that the Luoyang Foreign Language Institute taught spies at 3PLA, therefore Luoyang Language Institute is essentially a proxy of 3PLA. And the Federal Court of Appeal there just said you have to be very cautious when making determinations like that. Again, it's a decision I cite a lot in both responding to procedural fairness letters and my judicial review practice. Finally, Elwer Folly. v. Canada, Public Safety and Emergency Preparedness is another very useful case, and it stands for the presumption that membership in an organization, this can be espionage, terrorism, etc., it addresses the temporal aspect of this. So obviously, if somebody is a member of an organization at the time that they are committing espionage or terrorism, then they are inadmissible. What if they were a member of the organization before it started engaging in these activities? That was the topic that they had to address in El Werfali, and the federal court said that someone is not inadmissible if they were a member of an organization before it started engaging in activities that would result in them being inadmissible, subversion, espionage, terrorism, that sort of thing. Engaging of acts of violence. This was a big one. Again, we have a Borderlines podcast episode specifically about this decision, a Supreme Court of Canada decision, Mason v. Canada, Citizenship and Immigration, going back to a person can be inadmissible to Canada for security grounds for engaging in acts of violence that may or could endanger Canadians. In this decision, the individuals, there wasn't a national security component to the violence that they had committed. I believe one had dropped charges for domestic assault, and the other may have had a stay of prosecution for assault. Neither were convicted criminally, or the whole criminal inadmissibility provisions would apply. Instead, the Canada Border Services Agency went after these individuals, saying that they were inadmissibility to Canada on security grounds. And what the Supreme Court had to look at was, is it reasonable to interpret this provision, one is inadmissible to Canada for life for engaging in violence that would or could endanger the lives or safety of Canadian citizens, does that provision require a connection to national security, that the violence be related to national security? And the Supreme Court said that it did. Again, there's a whole podcast that I did with Deanna, and I'll link to that in this video where you can learn more about this case in a lot more detail, because as I commented in the video, I think it should have generated more media attention than it did what the government was seeking, which essentially was that foreign nationals and permanent residents in Canada don't need to be convicted of crime to be found inadmissible as long as there's reasonable grounds to believe that it happened. Here's a few more decisions on membership. So Akil v. Canada, Citizenship and Immigration. This involved, I believe it's called the South Yemen Liberation Movement, which is a lot of disparate groups. And the question that the court had to look at there is, okay, if someone we think may be a member of one group, but is it possible to be part of a umbrella organization, or not even if it's just a loose coalition? And the federal court said that membership, it can't just be like sort of multiple disparate groups that have a common goal. Some are contributing to terrorism, but not all the groups, but because they all have the same goal, no, that's not membership that gives rise to inadmissibility. However, membership generally does have a very broad interpretation. I've included in there the Canada versus Ecuador decision, where an immigration decision determining that someone was not a member of an inadmissible group was set aside, with the federal court saying that membership has a very broad definition, almost unrestricted, and that admission of membership itself is sufficient to determine if someone was a member of an organization. Finally, Abdullah v. Canada, Citizenship and Immigration. I talked before about how if someone was a member of an organization before it committed negative acts, then they couldn't be inadmissible. But what if they became a member of the organization after it had committed those acts and had stopped committing those acts? And the federal court in this case affirmed a lot of jurisprudence that if someone becomes a member of an organization after it has committed terrorism, then they will still be inadmissible to Canada unless the organization has undergone some sort of a fundamental change. So, for example, we acted once for an individual who IRCC was alleging was inadmissible to Canada because they were a Romanian spy, and Romania during the Cold War had spied against Canada. Our client was a member after, And so we just said, look, like, yeah, Romania may have spied against Canadians during the Cold War, but like during the period that our client was a member of the organization, the spy organization was a part of NATO. So there had been such a transformative change in the organization. Human or international human rights violations is another section that gives right to inadmissibility. I should note these inadmissibilities are lifetime inadmissibilities, and a person who is inadmissible for either Section 34 or 35, they are inadmissible to Canada for life. There's no humanitarian and compassionate considerations. Their family members are inadmissible as well. It's very sweeping. So here, someone's inadmissible if they've committed an act outside Canada that is a crime against humanity or a war crime, or if they are a prescribed senior official in the service of a government that, in the opinion of the minister, has engaged in terrorism, systemic or gross human rights violations. A list of the countries that have been designated can be found here. And as you can see, there were organizations designated from 1993 to 2004, with the most recent one, well, the second most recent one being Ethiopia during communism. And then flash forward to 2023, almost 20 years without a country being designated, and Iran was designated. And this has had very big implications because visa officers have to determine for all applications from Iran, a country where military conscription is mandatory, whether someone was in the top half of the public service, the military, and because if they were, then they're inadmissible to Canada. And basically, I can't go back in the PowerPoint, but the test basically literally is the top half. And then like you'll see federal court decisions where military-wise they'll list out all the ranks and figure out what the top half of the ranks were. So it is quite broad. Inadmissibility due to sanctions is new. It was introduced in 2023. I don't believe the regulations have been announced, but it's something to watch for, especially because Canada imposes more and more sanctions against, well, Russia right now in particular. But I have a list here of there's sanctions against a whole host of countries. Again, Russia is the big one, Ukraine, ironically. And there's if you Google consolidated list of sanctions, you can see a list of all the entities and individuals that Canada has sanctioned. A big one is Sharif University of Technology's Department of Engineering. And so that's one of Iran's most prestigious universities, and it's also one that is increasingly causing immigration problems. There also is, I don't have a slide for it because this occurred after the Ashton presentation, but in January 2024, Canada announced a list of 100 primarily educational institutes in Iran, Russia, and China that it considers to be threats to Canada's national security, and the implications of that are also still being felt. So those are the inadmissibility for security provisions. There are, of course, and beyond the scope of today's presentation, many other inadmissibility sections in Canadian immigration legislation. This includes for criminality, organized criminality, medical inadmissibility, financial inadmissibility, misrepresentation, general noncompliance with Canadian immigration legislation, as well as inadmissible family members. And I'll do separate videos for those at some point. There is a section, so you may have heard me say, well, they're inadmissible for life. They can't do H&C, humanitarian and compassionate. What can they do? Well, Section 42 of the Immigration Refugee Protection Act provides that they can apply for ministerial relief, essentially to the head of the Minister of Public Safety and Emergency Preparedness, that their entry to Canada would not be contrary to Canada's national interests. The issue, and this was obtained through an Access to Information Act request, is that these decisions take forever. So I don't have the column heads here, but essentially the first column is the legislative section. It used to be 34 sub 2, then they changed it, and now it's 42 sub 0.1. That change occurred in 2013. The second row is the year that the person applied for ministerial relief. The third row is the year that there was a decision. The fourth row was the decision. And the fifth row was how many years it took. So as you can see, it takes over a decade and increasingly close to 2 decades to render ministerial relief decisions. And I would submit that it's a big issue in Canadian immigration law that Canada has adopted an increasingly expansive concept of what constitutes inadmissibility, particularly membership, because in theory, people can apply for ministerial relief, but ministerial relief in practice takes over a decade to get processed. So I think that's an issue that will have to be sorted out, hopefully, and addressed in the future. So that was my PowerPoint. Again, I originally spoke to Ashton College for 45 minutes to an hour. I've tried to go through it very fast here. If you have any questions about anything that I've covered, please definitely feel free to send me an email or call, and I hope you enjoyed today's presentation.